Who do I have present? I have Miss Bliss. Anyone else present on that matter?
And I don't see Mr. West present. I did send that proposed order, albeit late last week. I did send that to him both via email and physical mail. I would just note the only change to that order was for that money judgment. Your Honor made a change to my request for attorney's fees, but all of the other orders remained unchanged.
All right. I will go ahead and sign the orders. Just noting not present today.
Very good. Thank you, Judge.
Anyone
Amy?
present on that matter?
Amy Powers here for Ms. Wolski. Mr. Foley and I have both signed off on the orders. I believe they're all agreed.
Okay. And those are the ones I'm to have, or are you sending them over?
We sent them over last week with both party signatures.
Okay. All right. I have those here, signing off on those orders. All right. Those orders are signed. Weaver and Weaver.
Good morning, Your Honor.
Good morning, Your Honor.
Morning. We have both counsel present. Ms. Dow and
Your Honor,
Mr.
if I may, I was not served with a notice of this hearing. We are in the process of requesting some additional assistance under the ADA from my client. I can handle the divorce side of it, not a problem. I feel like we need someone else to look at the Medicaid issue. Mr. Trotter and I have had some conversation with this, and we'll be picking it back up probably this afternoon sometime.
Your Honor, just response to that, if I may.
Go ahead.
Yes, Your Honor. So yes, with thank you, Counselor. Yeah, we have spoken with all due respect. We at this time just need to move forward with we're asking the court to move forward with the order of the sale of the home for many reasons. Essentially, as you are well aware, in December, the motion for temporary orders was filed. February, the attorney, Ms. Dow, was appointed, and just 1 month prior to that, the court investigator was appointed. The court investigator revealed that Mr. Weaver is competent, and so he understands and can participate in these matters. Susan's health is declining even more, and we really need to move forward with the sale of the home. For example, she needs to be closer to family. Family members are not here in the area. They're in Tennessee and other parts of the United States. She needs assistance with her care. She's living there by herself. She's elderly and has serious health concerns. So not only that, it's also a safety issue for her. The more we prolong this matter, I'm just very concerned for her well-being. And so while I understand that there's some Medicaid questions, any proceeds from the sale of the home that are subject to Medicaid would be most likely the responsibility of Mr. Weaver. So I really think that's a separate issue. And so I'd ask the court to move forward with the order of the sale of the home.
Your Honor, that is the central issue here. If we sell the home without setting up some sort of a Medicaid trust, my client will no longer be eligible for Medicaid. He has very, very little other income. We are looking at, I've identified a couple of possibilities for Medicaid trusts to deal with this issue. But again, we need someone who has actual expertise dealing with Medicaid trusts to look at this before we actually sell that home.
I may.
Real quick, you've already, go ahead.
Oh, so, yeah, I understand that we want someone to look into the Medicaid issue, but again, the proceeds from the sale of the home are simply going to be that, and Medicaid will do its thing, also. So I think really we could do those simultaneously.
So at this point, I understand where Mr. Trotter is coming from, because this has been going on for some time, and understanding that, yes, the husband may be competent, but there are a number of issues that complicate what for others may not be as straightforward on the sale of a house. So with that, the court is going to set this over one last time with the understanding that it needs to go forward. And the house needs to get sold, also understanding where the wife is at this point too, and her health things. So it's an overall trying to weigh the different needs of the two parties. So with that, Ms. Dow, do you know how quickly a trust, possibly a trust, can get done?
Your Honor, I would hesitate to answer that question with any sort of commitment to being accurate about it. I would say we're going to need at least 3 weeks to a month. I have gotten a number of suggestions from people who are more familiar with the Medicaid trust planning area, but we really do need someone to look at what we're suggesting to ensure that this is not going to backfire on my client. I realize that Ms. Weaver, these parties are separated. It's not her problem. It is, however, my client's problem, and it's a significant problem. I would say if you could set this over for a month, I can probably find someone who can tell me that I am either right or wrong about what our suggestions are.
Okay. So here's what I'm going to do. Let me find a calendar. Let's see, we're on May 21. All right, I'm going to set it over one last time to June 18. The matter needs to move forward as stated, and at that time, and the court is looking at that point to likely put the house up for sale. So this will be the one last time that this is done. So I would ask that, I mean, they deal with these trusts all the time, so it shouldn't be that complicated to get a trust set up if that is what needs to get done. So with that, I'll set it over to that June 18th day.
Your Honor, I'm sorry. Ms. Weaver can't, that day does not work for Ms. Weaver. I'm sorry. We could find, because she needs transportation, or transportation can't do it that day. What do you recommend?
Anytime after the 16th.
Anytime after the 16th, but just not the 18th? Okay.
Okay, then it would need to be the 25th of June.
Okay. Thank you, Your Honor.
That's a closed docket. Oh, hold on. That's a closed docket. That's right. Unfortunately, Tuesdays are our only day, so July 2nd is the next day.
Okay.
So July 2nd is when
Okay.
we'll continue to.
July 2nd.
Give you plenty of time, Ms. Dow.
All right, thank you, Your Honor.
Thank you, Your Honor. Thank you, counsel.
All right, I see we have Mr. Anagnostu. Do we have Samantha Brown?
Yes, Your Honor.
So what I am seeing is there was service on April 25th and no response. So I need to find out what's going on here.
That's correct, Your Honor. We filed the motion and we served Ms. Brown, and here we are. My client, he needs to have time with his son. He needs a son, and so we've asked for it's in our document, our proposed parenting plan, and we need to get that started. So we're here requesting that the court adopt my client's proposed parenting plan that sets forth Thursdays through Sunday. In addition, we're asking that when she's at work, that my client be allowed to do the care of his son. His son doesn't need to be left with her ne'er-do-well friends that she's had my client have to pick up his son from in the past. So we're asking for the court to adopt that parenting plan.
Ms. Brown, I don't see any written response at all. Can you tell me what's going on? Turn your sound and video on, please. Thank you.
Okay, can you see it?
Yep, I can.
I would like to ask for a continuance, please. I'm having a hard time finding an attorney to help me with this case. I've made a couple phone calls, and I was wondering if maybe I could get a court-appointed attorney so that we can move forward with this case.
You don't have a right to a court-appointed attorney unless except with rare exception. So
Okay.
that's something where, yeah. So at this point, my concern is it's been out there since April 25, and so that's an issue.
And I understand that.
What's that?
understand that being an issue. I am trying to locate an attorney that is within my means as well. It's just a little bit difficult with everything going on right now. I've had a few things come up lately that have set me back, not necessarily financially, but
So, Mr. Anagnostu, my concern with your proposed order or parenting plan has the child with the father for every holiday.
I didn't intend to do that, but, I guess
Well,
it's weekend and the holidays fall on it, but.
Yeah, I guess it's not the mom has every year Christmas Eve and Christmas Day. I don't think you meant to do that, but
Yeah, we put in because she celebrates Christmas on Christmas Eve day, and then he would get time beyond that.
yeah, it just doesn't state that. So that's my concern with your parenting plan. Like Father's Day, no issue, but 4th of July has every year with Dorian Graff.
Right.
So that's where the court is concerned. So what I'm going to do is, it is important that you have an opportunity to get an attorney. At the same time, it's important that the dad have time with his child. So what I'm going to do at this point is go ahead and in regard to parenting time, order that the father have visitation time or residential time in regard to the parenting plan, reserving on the holidays until those are looked at a little closer. So essentially adopting the parenting plan, but reserving on the holidays
Right.
until I think something more is done at this point. But noting that further consideration can be made, Ms. Brown, if you come back and make a request for further modification. We have more information. I don't like doing things without a full picture of what's going on, but at the same time, it's important Dad have the time that he needs. So at this point, I am
Your
going
Honor,
to,
can I say something, please?
as long as it's not, go ahead.
Okay. Thank you. So I have been meeting with Dorian almost every day, so that way he can have time with our son. He did not put that in any of the paperwork either. He did not put that in his statement. I think maybe for a month we did not meet, but I have been meeting with Dorian and he has been able to see his son. He has only asked me a handful of times to see Walter or to have time with Walter, and pretty much every single time that he has asked, I have accommodated to that.
I understand that, but at this time, you haven't reduced any of that to writing, and that's what has to be done on these kinds of dockets.
And I
Okay,
understand that, and I do have some concerns for our son's safety with being with Dorian as well, and I have written that on prior paperwork that I have submitted to court.
when did you submit it?
I have submitted for the first, this is our third time being in court, so I submitted a response the first and second time. There were 2 incidences that.
Okay, I don't want to hear any details because what I see is no response to what Mr. Anagnostu served you with. So I'm not going to consider it at this time. At this point, I'm ordering the parenting plan as proposed at this time. I'm also going to be appointing a guardian ad litem. Mr. Anagnostu, can you give me a sense of what your client's income is?
I'm sorry.
Your client's income?
He works independently. He owns a tree business. Probably estimated probably be $3,000 a month.
Okay,
And-
so I'll just have county pay for the guardian ad litem. Can I get the next 3 names?
Amy Turnbull, Karen Lawrence, Beth Phillips.
All right, so Mr. Anagnostu, do you strike any of those?
I'm sorry, I didn't hear the names.
Amy Turnbull, Miss Lawrence, and Miss Fellows.
No, I don't have any strikes.
Okay, so Miss Brown, you have an opportunity to strike. just means that you don't like one of them. So I don't know whether you want to strike any of those three names. We do a rotation of guardian ad litems. Do you know what a guardian ad litem is?
I'm sort of familiar with it, yes, not super familiar.
So it's somebody who looks into your position, the father's position, makes a recommendation to the court as to what the parenting plan should look like.
Okay.
Okay, so I'm gonna, do you want to strike any of those names?
I have no information about any
Okay,
of
all right. So we'll just go ahead and appoint Amy Turnbull. Mr. Anagnostou, if you can go ahead and draw up that order.
Okay.
And then county pay. And then, like I said, at least for now, I'm going to order the parenting plan. I'm going to reserve on child support so till I have more information as to income.
It's my understanding there's an administrative order for child support.
Is there?
Yeah.
Okay. Okay. All right. So that's what we're going to do for now. And then, and I know, Ms. Brown, that's not what you want to see as far as a parenting plan, but it's just temporary until we get the guardian ad litem in place and they do an investigation and we look at it further down the line. Okay. Okay.
Work schedule, so I can pick them up.
I do want to add, I don't know if there are any issues in regard to substances or anything of that nature.
There are.
Okay, I'm going to require also to be added to this that no party is to consume any alcohol or unprescribed drugs 12 hours before and during the time that they have the child. That includes alcohol, no alcohol, and no
Right, non-prescribed drugs.
no marijuana.
Okay.
Okay. All right.
And as far as the other people in the home goes as well, is that a rule for them too?
I don't have any authority over those people at this time.
Okay.
All right. And if you and Mr. Anagnostou can work something out, then you certainly have that right. If you want to reach out to Mr. Anagnostou, you can do that. Okay.
Thank you.
All right. All right. So anything else, Mr. Anagnostou, that I missed?
Not that I can think of, only that I can get, so I'll do a parenting plan. I'll reserve everything except for the weekday visit. And we would like that visit, of course, to start this Thursday, so.
Okay. All right. And there's always an okay, Ms. Brown, if you and the father agree to something else, it just needs to be in writing, signed off by both of you. So if there's any question about it, that we have something in writing, okay?
Okay. Thank you.
All right. All right. So with that, Mr. Anagnostou, let's go ahead and set this on to June 4 for presentation. So Ms. Brown, what it will mean is that Mr. Anagnostou will go ahead and put together the final orders that I ordered today. He'll send them to you, and if you agree that it reflects what I ordered, then you can sign off on it, and then you won't have to come on June 4. But if you don't agree with that it reflects what I ordered, then be here on June 4 for what's called presentation of the order. Okay?
Okay, thank you.
Okay. All right. That takes care of that matter for today.
Thanks, Your Honor.
Here, Your Honor.
Okay, we have Mr. Boaglio, we have Ms. Boaglio, we have Mr. Zandy, and we have counsel.
Yes, Your Honor, Savannah Williams for Mr. Boaglio.
Okay. All right. So with that, where are we at? We do have, first, let's look at the interim review of the court investigator. Did everyone receive a copy of that report?
I did.
I did, Judge. We received that Tuesday afternoon, forwarded to my client that same time. I was out on vacation from Thursday to Monday, so I have not been able to discuss specifically with my client. We did exchange some emails. Given the report, given the nature of this case, I think it would probably behoove everybody if they were able to respond in writing to that report. I know my client has commented on that, as do I. I would ask that for the GAL portion, if the court is inclined to make any changes or consider those, we set this matter and that argument over. I would prefer 2 weeks. I don't know what the court schedule is like. I understand June is a rough month. But just something that gives both parties sufficient time to have their positions heard and recorded in written declarations well.
You were just on the contempt matter, correct?
That is
Okay.
correct.
Mr. Broaglio,
Yes, Your Honor.
do you have any response to that request?
If Mr. Zandy hasn't had a chance to look at it, I completely understand those sorts of circumstances. I'm not sure as far as court propriety. It sounds like the issues of contempt and the other issue are completely separate. It just seems like that the report kind of does provide clarifying information into both matters, though. So that was my only concern with that. But so I'll leave that in your judgment, of course.
Okay. All right. So in regard to the report and the recommendations, the court always likes to have things in writing to make modifications to a present plan, just so everybody has an opportunity to review it and get their thoughts before the court as to they are recommendations. That's all they are. And so that's where I like to have the ability for the parties to weigh in on those recommendations. So I will go ahead and set this matter over to June 4, and that will be at 9 a.m. for purposes of looking further at the guardian ad litem report. My question then is, Mr. Zandy, I tend to agree, and counsel, I'll let you talk here in a minute, that it seems the contempt matter is tied in pretty closely to this. So I don't know what your thoughts are on that.
Yeah, I don't have an issue with that, Judge. I did receive, provided from Ms. Williams' office, it looks like a submission of a letter of such for Mr. Buaglio. I did review that this morning in my preparations for the docket. I don't know that we've had time to forward that to my client. Nonetheless, I'm encouraged by what the letter says. I think that's certainly progress. I hope that comes from a genuine place. I hope that this is something that we can springboard moving forward. But nonetheless, I do think there is a lot contained in Ms. Schaefer's information in that written report that directly kind of hits on a lot of the notions and concerns my client had about communication, telephone, text, and the like, that I think speaks volumes to kind of what her frustration has been and gives a lot of credence to that. And although I again am encouraged by the letter that was reportedly drafted by Mr. Buaglio, given the history of this, again, there is certainly ample room for concern on it. So I would certainly include that in my client's responsive materials for June 4th. But in the meantime, I think we kind of keep the status quo pending any entertained changes by the court or any submissions by the GAO based on the argument of the two parties, and we go from there. But that's kind of where we're at on that. That's kind of where I am. I just really want to see some change for the positive and the well-being of Adiel, because certainly she's worthy of that and should have that.
Can I comment briefly?
Hold on, Mr. I'm actually going to ask your attorney about setting it over as well. Okay. Your thoughts?
That is fine, Your Honor. I will need to file a motion to extend the number of hours on the case for my fees, but otherwise that is fine. I think that it is intertwined. I would just like a copy of that report because I have not previously received it because I'm only on the contempt part of it.
Okay. All right. Mr. Zandy, can you get a copy of that to counsel?
Yes, be happy to.
Okay. All right. And your motion should be done ex parte, just so you know.
Thank you.
All right, so let's go ahead and do that. Let's set the matter over to June 4. We'll take a look at things at that time and go from there. Ms. Schaefer, did you have anything you wanted to add?
No, Your Honor, I understand needing to have everybody respond to the report.
Okay.
Can I voice a concern about Adiel in the meantime? Our rent went up by $300 and our food assistance went down $200, and the supervised visits are costing $400 a month. That's a $900 a month swing. I have an autoimmune condition and I'm on disability and a fixed income. So I'm not sure I can even afford to keep going with the supervised visits with Adiel. I'm doing everything I can and family's trying to help. The report has thus stated so far that Adiel is not doing well with only having supervised visits.
I'm not going to do that at this time.
I understand.
Okay, so
I just didn't want it to reflect.
Include that in your response.
Okay.
Your response, okay?
Okay, thank you.
All right, so we will set this matter over to June 4.
Right on. Thank you.
Thank you.
Thank you.
Your Honor, I'm sorry to interrupt, but I think I have my court times incorrect. Is the Gall versus Gall matter at on this docket or in the afternoon docket?
Hold on, let the clerk look at it. That's what happened last time is.
I remember.
It is at 1 o'clock, sir.
Thank you, Your Honor. I apologize for this.
No problem. Anyone else here on that matter?
My client Shelby Veirs is present on Zoom today, and I do see Mr. Anderson as well.
Good morning, Your Honor.
Okay. So the first one had to do with the orders. I didn't receive any response. So where are things at this point?
And I guess I would defer to Mr. Anderson. He did come to my office to accept service of all of the pleadings. I too have not received any sort of response prior to today's hearing.
Mr. Anderson?
Your Honor, I asked if you could please give me a continuance. I've had enough time to go over all this paperwork. It's been kind of overwhelming financially.
When you ask for a continuance, what are you talking about? How long?
A few weeks. Talk to a lawyer and better go over this paperwork.
Ms. Bliss?
I don't have any inherent objections. I think my client is obviously wanting to move forward today, but I think given the fact that we haven't heard anything from Mr. Anderson, and if he is wanting to respond in some way or review the documents, or if he has any questions that maybe we can resolve short of coming to court, I'm obviously inclined to agree to that.
Okay. All right, I'm looking at June 11, which would be 3 weeks. Does that work for you, Ms. Bliss?
Yes, Judge, that's fine.
Mr. Anderson?
Yes.
Okay.
Thank you.
All right. So I will go ahead and set this over to June 11 at 9 a.m. Mr. Anderson, you do need to understand any response that you do has to be in writing. And so make sure to do that. Otherwise, the court will not just consider verbal responses. Okay.
Thank you, Your Honor.
5-8, Henriquez Fraidenburg v. Fraidenburg.
That matter's ready, Your Honor. Megan Gilmore on behalf of respondent Tanya Fraidenburg.
Anyone else present? Sir, take off your hat. Okay. All right, so we have Robert Fraidenburg present as well. All right, this matter is on for show cause for contempt and motion hearing enforcing terms of final order. So with that, are parties ready to proceed?
Yes, Your Honor. And I would like to know, did Your Honor have the opportunity to review our reply? It was slightly late because we weren't served with his responsive materials.
I don't recall a reply.
It was filed last Thursday.
It's in here. Doesn't mean it was in here when I reviewed things yesterday. Should have been, but.
And honestly, it doesn't contain any new information. We're just highlighting the fact that my client isn't the party that, caused the debt in this case. So I think we can move forward regardless. I just wanted to know that for the record.
All right, go ahead, counsel.
Again, just quickly summarizing the facts of this case, it's a relatively straightforward motion. A final divorce order was entered in October of 2023. Within that final divorce order, petitioner husband was required to refinance the home mortgage that he was awarded within the decree within 6 months and provide within 45 days showing his attempts to refinance. He was also ordered to pay my client $55,000 through the refinance or sale of the house within the same timeline. At this point, we're almost 8 months past the deadline, 8 months past the entry of the final divorce order, and we've seen no attempts whatsoever from husband to refinance or to put the home on the sale or to put the home on the market. Rather, as you've seen within the messages contained within our original declaration, husband has been extremely hostile and harassing and clearly has every intention of snubbing his nose at the court's order, absent being forced to do so. So at this point, we do ask the court to enforce the final divorce order in order that he put the home on the market immediately with an eye towards prompt and reasonable sale. In addition to failing to refinance or show any efforts to do so, he also has willfully and intentionally refused to pay the debts awarded to him within the decree. My client explains that for those months since the final divorce orders were entered, she has paid those debts to ensure that her credit hasn't been ruined. That came to a total of $1,186. That is for the FIBRA federal visa with the last four 0770 that was awarded to husband in the decree, as well as a Red Canoe line of credit with the last four 9596. So we are asking the court find him in contempt for willfully refusing to refinance, willfully refusing to pay the debts. We're asking the court enter a judgment for the amount paid by my client. We are asking that if he continues to fail to pay the debts, that he's ordered to satisfy the debts with the home proceeds. And we are asking for attorney's fees in the amount of $2,000.
Mr. Fraidenburg?
Yeah, I'm just asking for a little more time. I've got a new job now. I have the opportunity to work a bunch of overtime to get this taken care of. I have started a refinance process. I can do it. I just didn't have the money then, and I can get it done now. The sale of the house is not going to benefit anybody. It doesn't need to happen.
So when you say that you can do it now, how long are you talking about?
I wrote in my statement 6 months, but I don't figure that I need that long. Okay. I just wanted to make it to have enough time to make sure we don't come back here.
So what about the debts?
And honestly, the two that I haven't paid, I have never got a bill. I don't know. I understand that's my responsibility. I never took care of the bills in the marriage. None of them. She did everything. It's not that I'm not paying it. All right. I just don't understand. She has said nothing to me about it before. I told her, I never said that I wouldn't pay her this amount. I told her before that I couldn't do it right now. Now I'm in a situation that I can do it. I don't make near the money she makes. I'm just trying to get by. I'm trying to survive. It's not very easy.
Thank you. Ms. Gilmore?
Just briefly, Your Honor, this was an 18-year marriage where both of the parties were represented by counsel at mediation. I think 6 months was gracious of my client. That's more than we often do. Often you see 30, 60, or 90 days. And I think that the communication between the parties really shows that but for bringing a motion for contempt, he wasn't going to comply. My client paid me to not only write correspondences, but emails, follow-up emails. My client had every intention of avoiding this motion, and it's been relatively costly to do so. I don't think that, given this is an election year and there's no indication that the market is going to change, these parties are going to be in a better situation in 6 months. And frankly, it's going to be winter and the home is going to be harder to sell in 6 months. I would suppose that at most 30 days, but at this point, again, to have further reviews and further setting it out, it's only going to be more costly to my client.
All right. So here's what I'm going to do. As to the request to enforce the terms of the final divorce order, the court is going to allow 30 days. So by July 1, either have it refinanced or the terms of the decree are going to be enforced and the property put up for sale. You were both represented by counsel at the time of the decree. So being past the time that was set up, then whatever was going on didn't happen. But I'll give you until July 1, as I said, and if not by that day, then the house will be put up for sale. So that'll give you some time if you're working now. Refinance doesn't take that long. So hopefully, and once if the house does need to be put up for sale, you will need to sign off on the appropriate paperwork to list the house. If in fact you don't, then the matter needs to come back before the court, and the court will be looking to have a court commissioner be directed to sign off on your behalf. So if you want to say in this, you need to follow through and do what is required of you. As to the motion for contempt, obviously the debts were not paid. And at the same time, the court can't necessarily find a willful and intentional violation at this point not to pay. Sounds like there's been some financial hardships that have gone on. And so at this point, anyhow, the court is not going to order contempt. But those debts need to get paid also within the next 60 days, get them paid in full. It doesn't sound like there's too much that's outstanding from what I'm understanding. But I will grant a judgment for the amounts that your client paid Ms. Gilmore. The fact that this even needed to come before the court is going to order attorney's fees of $1,500 total between the two matters. And those are to be paid within, I'm going to put an outer date of 6 months just to not pile up too much debt at one time. So that's what's going to be happening.
Does the court, we could potentially set it out into July, and so we can set both a presentation as well as a review, and I can strike if it's satisfied.
Mr. Fraidenburg, does that work for you?
What's that?
To set it out, well, two things need to happen. One, Ms. Gilmore needs to prepare an order that reflects what I ruled today. And the second thing is that need to look at whether or not the house was refinanced or whether it's been put up for sale. And if everything's been done and everything's been signed off, then you won't need to come to that July court date. But if it isn't, then you'll need to show up on that date as well. So I would be looking at July 9. Does that work for everyone?
Yes, that works for me.
Mr. Fraidenburg, does that work for you?
Yes.
Okay. So I'll go ahead and put on presentation and to check on sale of home on July 9 at 9 a.m. All right,
Thank
Counselor,
you.
go ahead.
Thank you, Your Honor. For the record, Carly Bliss on behalf of Stephen Edmison, moving party for purposes of today's motion. Before you is my client's request for specific relief cited in his motion for temporary family law order, specifically as it relates to allocations of who is paying the Mini Cooper debt. There's an issue as to insurance. There's an issue as to some key fobs that have gone missing that my client's requesting be reimbursed, and the remaining items of Ms. Edmison that has been left in his storage unit. Looking first to the allocation of debts, we were last before the court in March. During that hearing, the court did not make any specific ruling as to who is to pay which debts. The court did award Ms. Edmison temporary use and possession of the 2011 Mini Cooper, which has an associated debt with that for a $233 monthly payment. My client's asking the court to order that Ms. Edmison pay that debt, given that she has sole possession of that vehicle in Oklahoma. At the time of our motion, we had requested an order from the court requiring Ms. Edmison to obtain insurance for that vehicle. I've since learned that she has obtained insurance for that vehicle. My client also maintains insurance for that vehicle. Pursuant to the temporary family law order, the court ordered no changes to insurance. So we are asking the court to allow my client to remove that vehicle from his insurance today, given the fact that Ms. Edmison also carries insurance for that car. As it relates to the vehicles, or the keys, excuse me, my client provides in his declaration that prior to Ms. Edmison removing herself from the property, she had 3 days of unhampered access to the home and the items within it. My client provides that upon her leaving the home and upon his return, he realized the fobs and the keys for his Corvette and his other Mini Cooper had gone missing. He has repeatedly requested they be returned by Ms. Edmison. She claims to not have them in her possession. It's my client's position that they were there prior to her leaving. She was in the home with 2 other individuals. The keys did not just walk away on their own. The keys, in order to be replaced, are a significant cost. My client has provided documentation showing that it's going to be $830 to replace those 2 keys. My client is asking that Ms. Edmison be responsible for paying those as they were lost or taken on her watch. Lastly, as it relates to the remaining items of Ms. Edmison, excuse me, my client provides that he is maintaining a storage unit for her personal property, essentially. She did come and retrieve a substantial amount of her property, but some of her property still remains. My client is paying a storage unit every single month for those items. We are asking that either she return to the state to remove those items, or she arranges with those that are still in the state to remove those items, so my client can alleviate the need for having that storage unit. Those are our requests today. We do believe that they are reasonable. They were not addressed at the prior hearing, so this isn't essentially a second bite at the apple, as Ms. Edmison is trying to convince the court. These are very necessary issues that unfortunately weren't able to be worked out between counsel, so this motion was necessary.
Mr. Henriquez?
Yes, Your Honor. With regards to the Mini Cooper, this is a rehashing of exactly what happened at the hearing. We requested the truck, and as indicated in Mr. Edmison's response, he even acknowledged that there was an agreement with regards to the truck. So what happened is the parties had an agreement that my client was going to get this truck that doesn't have a debt on it. We come to court, but because she responded to the divorce and because she has raised issues, he's now angry and is going to take it out on her. And we come to court, and at the hearing, we said, we want the truck. It was bought during the marriage. There's no debt on it, and she needs a truck. She needs transportation. And he said, absolutely not. The truck was not bought during the marriage, and he created an issue about that. And the court ultimately indicated that you weren't going to order the truck to my client, and she was to pick a Mini Cooper. So, she got a Mini Cooper instead of the truck that doesn't have a debt on it, and has, got that to Kansas where she lives now. And now he's raising this issue about the debt. The temporary orders indicated that he was to pay debts in his name. And this is a temporary order. So she has temporary possession of a truck or of the Mini Cooper that has a debt on it. Is standard procedure that the party with all the means, which is Mr. Edmison, my client is, as we indicated, just marginally employed at the time. She's on Social Security and, doesn't have the income that Mr. Edmison has, pays the debts on a temporary basis. That's what you ordered, and they're asking for reconsideration.
This is Matt.
Way beyond the time when you can ask.
This is Matt.
So we're asking that the court not change its order with regards to who pays the debts on a temporary basis. As indicated, that's a motion to reconsider. That's beyond the timeline and just not appropriate on temporary orders, that he continues to pay the Mini Cooper so that my client can have transportation. As indicated, she got out here and they sold her vehicle, and he's got all these vehicles, and anyway, he should continue to pay the Mini Cooper debt. That was the court's ruling after he refused to allow her to take the truck, and now says, well, she was supposed to take the truck in this reply declaration. With regards to the insurance, my client got the vehicle to Kansas, and she had to have insurance in Kansas, so she does have insurance on it. We agree, but I disagree that counsel and I have talked about this before filing the motion, that he can discontinue the insurance here. Because she did have to get insurance there to be able to drive the vehicle in Kansas. So with regards to the key fob, that was brought up previously. There's discussion about it. My client doesn't have them. This is, just an attempt to continue to litigate these issues against my client, who doesn't have the ability to afford attorney's fees. It's in declaration, says she doesn't have those. It's in this declaration, my client's reply declaration, that she didn't take them. She doesn't have them. They can say, well, it was here then. And as she indicated, he had to let her in the house because she didn't have any keys to where her property was being stored. So he had to come and let her in, and he had people there. She didn't take the key fob. She doesn't have them. This is, it's just inappropriate to seek fees. This would be, if he wants to continue to press this issue, take it to trial, and we have people testify who was there and where they were and whether or not ultimately there's an award of some kind of fees for the key fob. But on temporary orders, she clearly in her declaration says she didn't take them, doesn't have them, and here we are. It's not an issue that should be continued to be litigated. With regards to the personal property, that has been an issue. We came out here, and my client came out here and tried to get all her personal property, and it was quite frankly a fiasco. It's a problem. My client is of limited means. She's in Kansas. She traveled out here with all her possessions, and then Mr. Edmison decided to file this divorce. We ask that with regards to the personal property, that my client be given time. She came out here, she got all that she could, and took it back there. They had to rent a vehicle to get it back. And initially, Mr. Edmison had indicated he would have all of her personal property delivered to Kansas, but that, because he's angry now and we have to litigate everything, has gone by the wayside. So my client is the disadvantaged spouse in this matter, and she's struggling, moved all of her stuff out here in reliance on this marriage, and is struggling to try to get all this stuff organized. She's done the best she can, so we're asking for it to remain in storage, and she doesn't have the means to pay that. It was actually being stored, some of her stuff was being stored at his children's residence, which is adjoining this property, and they had, it's my understanding, they had a barn structure. So why it's in a paid storage unit at this juncture, just not, real sure how that happened, but my client needs some relief from what's going on, this continued litigation from Mr. Edmison.
Ms. Bliss?
The issues are very poignant, Your Honor. These matters that are being brought before the court today were not addressed on temporary orders back in March, which necessitated this motion. Ms. Edmison has had, since that hearing, 2 months to obtain her personal property. I understand that it's long distance, I understand, but the court did give her the opportunity to come, gather all of her belongings, and then leave. My client is now left with a paid obligation to maintain her possessions. My client provided in earlier declarations that Mrs. Edmison's property was expansive. There was a lot of canning supplies, a lot of miscellaneous items that were strewn about in various different locations. My client now indicates that he is paying a storage unit for the remaining items. He should not be obligated to pay that. So we are asking the court that she have maybe a date certain in which she needs to come out or make arrangements. I do understand that when the parties were arranging for her to retrieve her items last she was in town, there were friends or relatives that were able to assist in that. I don't know if they have the ability to store her items for her, but again, my client is paying spousal support, paying all of the expenses currently, and paying for a storage unit that is housing just Ms. Edmison's property, which she was to have come and retrieved back in March. Again, with the key issue, this is almost a $900 issue. Yes, this could be addressed at trial. However, in the meantime, my client doesn't have any access to 2 of his vehicles. He needs these keys replaced. He is asking the court that since they were missing, taken, what have you, on Ms. Edmison's watch, that she'd be financially responsible for their replacements.
All right. So in regard to, based on the files and record, the court finds following. In regard to the storage unit, the petitioner is to take a video of what is in the storage unit and provide it to the respondent's attorney by May 30th at 12 p.m. The respondent is to determine by June 5 if she wants any of the items. Then her attorney is to advise petitioner's attorney by 5 p.m. that day, and arrangements will be made to pick up the items by July 1. At 12 p.m. Anything remaining after that date or time can be disposed of by the petitioner and not before. The petitioner can close out the rental by that date. As to the 2011 Mini Cooper, what I don't know is what is the monthly payment?
I believe we provided a document that said $233.
Okay. All right. So in regard to the Mini Cooper, the respondent shall be responsible for the car payment and insurance on the vehicle effective as of May 1, 2024. Actually, we're almost to the end of May, so June 1. And the petitioner can drop the insurance on the vehicle as of that date. The request for reimbursement of the March 2024 Mini Cooper loan payment and replacement vehicle keys is denied. It can be taken back up at the time of trial, so I guess I should say reserved for trial. At this point, the court simply doesn't have any way to know what happened to those keys. As to the request for attorney's fees by each, that is denied. From what the court sees, both parties have some fault in this whole matter, so no attorney's fees will be ordered for this purpose today. Presentation.
we want to stick it on that June 11. I don't know what your dockets are looking like. Is the 4th getting pretty full?
June 11 might be a better day.
Okay, we can do June 11. I'll prepare that order.
All right.
Thank you.
Thank you.
That matter's ready, Your Honor. Megan Gilmore on behalf of petitioner and non-moving party, namely Timothy Fragel, excuse me.
All right, can you pull that mic right in front of you and just counsel so you know that she's present here in the courtroom, Ms. Fragel? All right. All right, these are your requests. So it's your opportunity. Do you want to add anything to what you had?
In my second declaration where I was saying that he was lying on his financial declaration, I do have proof of that.
Okay. If you haven't filed it by now, I can consider it is filed. Okay. When did you file it?
I believe about 2 weeks ago.
Okay. The financial declaration?
Yes.
Okay. Okay. Anything else you want to add to your statements or argue from your statements?
No.
Okay. All right, Ms. Gilmore.
I'll keep my argument relatively brief. The parties were married on July 13th, 1997 and separated for a final time when their legal separation was finalized in Oregon on June of 2008. Within that order, the duration of the legal separation is defined as unlimited. The order specifically states that neither party is to be awarded spousal support. This was prepared and agreed by petitioner of that action, but wife in this case. Respondent is now precluded from asking for spousal support especially on a temporary basis without the court making a finding regarding the legal separation order after 16 years after the legal separation was entered. A decree of legal separation is a final order and it is not interlocutory. Under the case of marriage of Moody, and I can provide the court the site of that, the court held that reconciliation does not invalidate a decree of legal separation. Therefore, it remains enforceable and in full force and effect. We do ask the court to deny the request for spousal support based on the lack of standing in the previous order. Moreover, respondent fails to present anything in her underlying motion to support her claim for a need of support. We have one pay stub that was submitted within discovery. She provided no financial information on her behalf within her motion supporting her request for a financial declaration within her underlying motion. Through discovery in this very short turnaround case, we still haven't received any bank statements or other information outside of, again, one pay stub provided. She also makes argument in her reply that she's not receiving Social Security based on a need rather than insurance. However, she does include in her declaration that the fact is that if she does receive spousal support, her benefit would go away, which suggests to me that in fact it is SSI rather than SSD. And she's relayed to the government that these parties have been separated because my client's income would be contemplated. So she's been benefiting since 2012 that these parties have been separated.
Your Honor, that's not true.
Stop. Go ahead.
I think it's also important to note that she claims within her financial declaration that her rent's going to be over $2,000 a month. However, in her actual declaration, she notes that she only pays $350 for rent. We provide in our materials, the respondent has clearly ability to make ends meet as she's going on trips to Mexico and the like, where my client doesn't simply have the ability to do so. As to my client's income, he has a gross annual income for 2023 of $87,775. I divided that by 12 months, which gave him a gross of $7,314 or net of $5,070. My client recently was injured and likely estimates to be out of work for another 6 to 12 weeks, which is similar to what happened last year when he was receiving short-term disability and was out of work. My client is going into the negative each month based on his financial declaration alone. My client simply does not have the ability to pay support, and we don't believe that wife established a need. So we do ask the court to deny spousal support. Looking to some of the other requests, we do ask the court to deny respondent's request to access the home. As the court's aware, the court in another action entered a DVPO that protected my client against respondent. I won't go into the details of that, but mainly regarding concern of respondent's mental health and her threats of violence to my client. My client has remained in the home since this action has been pending, and we ask the court award him the home on a temporary basis. We ask that respondent does not have access to the home and remains within 500 feet of the home, similar to the restraints within the restraining restraining order. There's ongoing issues regarding personal property, and I believe that that is the basis for the request of access to home, is she wants some of her personal property, which my client has been happy to facilitate. However, she continues to fail to exchange it. My client indicates in his declaration that he's more than willing to even pay for a storage unit in the interim to facilitate this so that wife can have access to her personal property. But again, it just simply does not make sense that these parties have equal access to the home given the restraining orders and the previous facts of this case. So we do ask the court deny spousal support, deny wife's request to have access to the home, in order that she pays her vehicle, which she has been doing since this case has been pending.
So Ms. Gilmore, is the protection order still in place?
No, it was extended through April. My client, because there was no contact or a violation of that order, he decided not to extend it. So that is why the issue is before the court, is because the restraining order has lapsed, which would technically allow her access to the home, but for my client residing there.
All right. Any response?
Yes, he said that I had put down 350, which is what I'm currently paying. When I did my new financial declaration, I made it for what I would have to pay after our separation. So that's the discrepancy. I did list 8 different apartments, with the medium being $2,070 per month. The restraining order has lapsed. And as far as when we were separated, since then, I have become 100% permanently disabled, and Tim has taken care of all of the bills and all of our needs. Regardless of whether he was hurt, he is getting disability of some kind and therefore has the ability to pay. He's making a lot more than what he said he was in his financial declaration, as proved by his pay stubs, which you have. There is no reason for him not to pay child or spousal support.
So Ms. Gilmore, in regard to the legal separation, that was done in Oregon, is that right?
Yes, Your Honor.
Okay. And did you file any part of that? Because I don't recall seeing it. When
I did. I filed the entirety of that. Wife had only filed a portion, so we had filed that with the court. I'm looking, sorry, give me 1 second. That was April 9th, 2024. It just references general judgment.
Oh, here it is. Never mind. I missed it yesterday when I was trying to find it.
And I was referencing, I believe, which was page 9 within the PDF, but the page is 8 on the form, referencing that the legal separation duration is unlimited.
So I'm looking at under paragraph 11, page 7, it says no spousal support or spousal life insurance is ordered in this case. So, and then, what was the other page that you said, Ms. Gilmore, you were looking at?
It's that, yes, it's under, like I said, the PDF is 9, but on the section, it's section 17, page of the order 8, and it says the length of separation shall be unlimited.
So my question to you, Ms. Gilmore, is this is a legal separation document that I'm looking at. It says as to maintenance, or what is called there, is in this case, but now we're looking at a different case. So I'm trying to figure out how you say that that carries over to this case.
Though it's the same marriage, it's the same parties. Under the full faith and credit clause of the United States Constitution, we are, and under state v. Veirs, Washington is required to enforce and acknowledge orders of other states. And this is a final non-interlocutory order. So in the case law that I previously cited indicates that orders of legal separation remain in full force and effect, even regardless of the parties reconciling. So I think that Washington's required to enforce this order, and I think that it remains in full force and effect for an unlimited duration and addresses spouses for the parties. The case law that I'm referencing suggests that she needs to bring a petition to modify potentially, but this spousal support for the purpose of jurisdiction on the parties has been resolved.
And when you say a petition to modify, are you talking about the Oregon matter, or are you talking about here?
She could do either. It's similar to like an entry of a parenting plan in Oregon. She could bring a petition to modify here, or she could bring a petition to modify there. But it is still an enforceable order. It would be a different situation if she had checked the box that it was a period of time, or she had sought to modify upon the alleged reconciliation. But that's not the facts of this case.
We believed we were married. We believed that we had checked the 2 years. We have been in a committed, intimate relationship for 28 years. And I have become totally 100% disabled since that was signed.
All right.
Oh, and I do not receive supplemental security income as stated in their declaration. I never have. I was denied because of my husband's income. I receive Social Security disability income.
So anything further?
No.
I would just note that the court's aware of this, but even if the parties were in a committed intimate relationship, spousal support cannot be ordered in those type of cases. So I think she's precluded from spousal support under either analysis.
So I did review the files and record. I did miss this one. I knew what it said, but I couldn't find it. That at this point, what the court's looking at is a procedural issue. And because of that procedural issue at this time, the court cannot order maintenance. And so at this point, maintenance is denied.
Okay.
And I'm not even going to go into the need and ability. I think there are additional questions and issues that come up in regard to that. Access to the house. So, Ms. Gilmore, can you tell me, and I'll get to you in a minute, how much your client indicates she still has in the house?
And again, I would mainly have to rely on our previous declaration from our other motion where we submitted pictures. I think it's mainly has to do with a lot of like personal property items, toiletries, clothes, things like that I imagine she would want.
And that's something that he'd be willing to move into a storage unit?
Yes.
All right. So you had something to say?
Yes. He has already broken and damaged my personal belongings by just boxing them up. I was allowed to in the house 2 times since December because of needing the facilitation because of the restraining order or whatever it was. That's not on me. I got clothing and toiletries the 2 times I got to enter the house. I was not given enough time to move all of my belongings, and I would like to be the one to pack them up and move them as he has already damaged and destroyed my property.
And Your Honor, I can intervene. My client's happy to facilitate that. He can have his brother have her have access. That's not a problem. If she prefer to pack it up so we don't have to deal with any allegations back and forth, we're happy to do that.
Okay. All right. So I will go ahead and grant access. You'll need to work it out with Ms. Gilmore as to when. And I would go ahead and just allow 2 days again to come in for the timeframes that you did before. Get that worked out. And then we can go from there.
And do I need to be supervised by his brother during that time?
You do.
Fine.
And even though the protection order is off at this time, he has the right to possession of the house. I'm ordering that you would need to have somebody with you, being the brother. And quite frankly, it's better all around. Okay. And I would encourage everyone to take pictures and document what you do.
And he had offered to pay for that storage unit. Is that going to be?
So at this point, I'm not ordering the storage unit. I'm just having you go ahead and just go into the house and get your things.
Okay. And what do I do with, I'm living in a 200 square foot cabin.
Okay. Ms.
No, we'll be fine to pay the storage unit.
All right. So I'll go ahead and allow the storage unit. He'll pay for it. So you have a place to move your things into.
Okay.
Okay.
And there's also no order on who's supposed to pay my car payment?
Okay. I'm getting to that.
Okay.
Oh, the car payment?
Yes.
So in regard to the storage unit and the household expenses, those will be paid by the petitioner. You will need to pay your vehicle payment.
Okay.
Okay. All right. So let's go ahead and set presentation to June 11. Hopefully you'll have something figured out by then as to date and times.
And Your Honor, I'm fine preparing. I know it's her motion if she feels comfortable, whatever.
Okay.
Whatever the court would like to do.
So Ms. Gilmore will go ahead and prepare the order. And then we'll have presentation on the 11th. If you agreed that it reflects what I ordered, you can sign off on it before, and then we can strike that hearing on June 11th.
Okay.
Okay. All right.
Thank you.
Oh, am I allowed within 500 feet of the home? Because that wasn't a motion, that was put on his declaration. He has not petitioned the court for that.
And I can just say, with my understanding of the order, she just doesn't access the house without an agreement and a third party. I think that that's sufficient. That's my understanding of the court's order. Is that correct?
Correct.
Okay.
Great.
So I didn't plan on adding any specific language about 500 feet.
Okay.
Also, all of my mail is still going there. I'm not in a permanent residence yet. How am I to obtain my mail?
So that's something that you should be able to change at the post office.
Right, but that's my permanent address. I'm staying at a temporary location.
Okay. Ms. Gilmore, I don't know if you have any thoughts.
A PO box? I don't know.
So
okay, I'll
that's
figure it
probably a
out.
good idea, or someone that will receive your mail for you.
Okay.
Okay.
Thank you.
All right, counsel, go ahead.
Thank you, Your Honor. And this matter is brought by my client, Yadira Henriquez, who's the petitioner and moving party for purposes of this motion. Before you today is a motion for a temporary family law order, specifically as it relates to a parenting plan for 13-year-old Daniel. This is a 16-year marriage where the parties had 3 children born at issue of this marriage. Only one remains under 18, although I would note that they do have a daughter who is 18, but is only a junior in high school. So if the court does order child support, regardless, she would need to be included in that as she's still enrolled in high school. Before you today, my client is making a request for an equal residential schedule as it relates to Daniel. She provides for the court that during the course of this party's marriage that while Mr.'s schedule was a little more flexible, he was able to take time off work more frequently, but the parties jointly raised these 3 children. My client provides that since the party's separation, Mr. has essentially begun withholding the child from my client, indicating that she can only see him if she pays for him. Obviously, that's inappropriate conversations to be having in general, but especially in front of the child, which my client provides for the court has happened on several occasions. Even in Mr.'s responsive declaration, he indicates that both parties are bonded with this child, that this child loves both of his parents. There is no purpose for limiting my client's time with this child, as Mr. Henriquez has done since the party's separation. Neither party, with the exception of my client making a request for withholding the child for a limiting factor, neither of these parties have entered any sort of 191 factors in their proposed parenting plans. Mr. has essentially requested sole decision making, which I would argue is another basis of controlling the situation. Again, throughout the course of these parties' relationship and marriage, and even post separation, they've both cared for the child, both made decisions for the child. So this is essentially a grab for a meal ticket, which is what my client has indicated has historically been the case. My client is making a request for a joint residential schedule. Again, this is a 13-year-old child who is well bonded with both parents. Both parents are capable of caring for this child. There's no history of neglect or abandonment or anything of that nature, no history of domestic violence or substance abuse. These are both loving parents who just need a little bit of help from the court. We are making a request for a week on, week off. I understand that Mr. is requesting essentially maintaining the status quo. I would ask the court to consider why this is the status quo. Again, Mr. has implemented this schedule unilaterally. My client provides in her declaration that she essentially didn't want to rock the boat until we move forward with the court proceedings because of the fact that Mr. has a history of withholding the child. She essentially tells the court that she abided by all of the rules and schedules that Mr. had implemented just so that she could continue seeing her kids. Again, this is a request by my client for a joint schedule. For purposes of child support, my client provides that she earns $21 an hour. Mr. earns just over $1,000 a week or $3,900 net a month. With a joint residential schedule, it would come out to Mr. paying my client, but she's not making a request for child support at this time. She simply just wants to have some substantial time with her child, which she hasn't been allowed to do at this point. I understand in Mr.'s responsive materials, he provided some credit cards that need to be paid. That was the first my client has essentially heard of that. She provides with the court that she's never accessed any of those credit cards, that historically Mr. has said you need to pay X amount of dollars. When she made requests for credit card statements or anything of the like, he refused to provide them to her. So at this point, I'm asking the court to reserve on any sort of debt allocation pending further discovery. My client's requests are reasonable and are in the best interest of this 13-year-old boy. So we are asking the court to find the relief that we've requested in our motion.
Ms. Powers?
Thank you, Your Honor. And for the court record, my client, Mr. Henriquez, is present in my office with me today. We really have two issues before the court today. We've got the parenting plan and we've got child support. The parties have been separated. This is going on their 4th year of separation. Since the parties separated, all 3 children have resided with my client, including the child who has now aged out. He's continued to live with my client. Throughout the course of this 4 years, the parties have followed a schedule where the kids live with my client and they visit their mom on the weekend. This isn't a situation where my client has withheld and dictated the schedule. It's been 4 years. This is what the parties have been doing. My client admits in his declaration that there were 2 weekends he did withhold the child in March. He explains that that was not because of child support. That was because of concerns his son brought home about being left home alone. My client does not view these children as a meal ticket. He has been their primary provider for 4 years. He has paid the rent. He's paid all of the utilities. He's paid for car insurance as kids started driving. He's paid for cell phones. This isn't a situation with a meal ticket. This is a situation where mom has been living on her own and has not been supporting this family. The mother in her reply declaration includes some evidence that she's given money directly to the kids. Again, that's not child support. That's money given to the kids to do what they want with. When we're talking about child support, we're talking about both parents being responsible to help with the basic living expenses for the kids. It's been 4 years that this parenting plan has been followed. We asked the court to keep the status quo and have the 14-year-old continue to reside with my client. In terms of the 18-year-old daughter, she is a senior in high school and she will be graduating next month. So we recognize she really shouldn't be part of this parenting plan. We have asked the court to order child support for her through June, recognizing that beginning in July, it will be a one-child child support order. Briefly, my client did request some visitation time. The mother has agreed with that visitation time for a vacation that they'll be taking in the fall. As we turn to child support, we agree that the mother earns $21 an hour, full-time hours. We've provided information showing that my client grossed $4,881 per month and has netted $4,050.93. That was all calculated based on his April 19th wage stub, which was filed with the court. The mother indicated in her reply declaration that the father has a second job. My client denies that. He only has his one job that he works. In the mother's reply declaration, she also indicates that the daughter has been required to pay rent. My client denies that as well. He has not charged the kids rent. He's paid for their expenses. We asked the court to enter a child support order. The mother provided information that she does insure the kids. It would be appropriate for that medical insurance costs to be credited in the child support worksheets. The information that was provided to the court showed the breakdown of costs for a parent-only plan versus a parent plus child. I will note that the deductions on the wage stubs are higher than the amounts shown on that coverage page. So I don't know if that coverage page was a year old, but we agree that that should be included in the worksheets. We ask that the court enter child support and that the court give my client the tax deductions. He has been the sole provider for the last 4 years for these kids and should be able to continue to claim the kids on the taxes. Thank you.
Ms. Bliss?
I think I will rest with my former argument, my pleadings, Judge.
Okay. So based on the files and record, I guess my question to you, Ms. Bliss, is that if a particular plan has been followed for some time, why there's a need to, and I know it may be because she wants it, but in regard to the children, I don't have a benefit of a guardian ad litem talking to the children at this point. So I'm just curious if you know at this point how it would impact the children to change the plan that they've been following for so long.
Sure. And I mean, honestly, I have, my client's report of the children want to spend more time with her and things of that nature. We don't have the benefit of a guardian ad litem. I also don't think there's a real need for one at this point. My client is simply just requesting additional time with the children. Again, the schedule that's currently in place was implemented at Mr.'s direction. And my client indicates that she has always asked for more time. She indicated that when she did leave the relationship, she attempted to take the children. He wouldn't allow her to. So it's simply just a request for additional time. And I don't believe that there's a basis to limit her time with the children, even granted the fact that there has been a status quo for the last 3 years.
Ms. Powers, anything further?
I would just say that this is what the parties have done for 4 years. My client denies that he was the one who dictated this schedule, and it's been working for the kids. And we would ask that the same schedule continue. We don't see any need for that to change.
Here's what I'm going to do. I'm going to actually kind of do a combination of things. One, I think it's always good for children to have consistency. I don't know exactly what all has gone on here, and it's always hard to tell. But obviously, they're also at ages where it's important that they have an opportunity with both parents. So what the court is going to do is maintain the current schedule until the children are out of school. And then for the summer, it will be switching to week on, week off. And then prior to going back to school, it will switch back but I'll allow either party to bring it back. If the children are doing well and like that schedule of on, off, the court doesn't really see any basis not to have that. But at the same time, it's more about the children and maintain that consistency. So it's kind of a combination of, hopefully I'm making sense, and just see how it is. But again, it can be brought back before the school year starts and take another look at it if we need to. I do want it understood that neither parent is to talk about this litigation or what's going on here to the children. And both parents are prohibited from posting anything regarding this matter on social media, as that is too easy for a child to see what is going on as well. And I just want to add, you may have an 18-year-old, but again, they, like the other, want to love their parents, both their parents. And it's just completely inappropriate to say any negative comments or remarks in regard to the other parent. Just keep it positive. Let them love both of you. In the long run, that's going to serve both of you much better than talking negative about the other parent. In regard to child support, the income of the mother will be set at the $2,920 per month net, and the father $4,050 per month net. There will be given credit for the number of overnights. I don't know exactly what that is. And for claiming the children, I'll go ahead and allow the father to claim them for the odd years and the mother for even, well, reverse that. I meant the opposite of that. For even years, the father; for odd years, the mother. She is going to be paying child support, at least at this time. So for now, that's what we'll do. And then mom should be given credit for the insurance that she's paying as well. That should be written in. The debts, I don't recall being a part of the motion, but that'll just be reserved.
Ms. Powers, I don't think we need a presentation date, do you?
No, I think we could probably agree on orders.
Okay. Thank you, Judge.
Right. Thank you.
The matter's ready, Your Honor.
Okay, we have Ms. Winkles. Yeah,
I'm here, Your Honor.
Robert.
I see my video isn't turning on, and I have no idea why. Do you want me to try logging back in? Or are you okay with this?
That's fine.
Okay, I apologize for that. It's never happened before, but here we go.
Technical matters. All right.
Sorry, Your Honor. Is my audio much clearer than my video?
Yes, I can hear you fine.
Did the court, I just want to make sure, the court read Mr. Agovino's reply declaration filed on Thursday, as well as the police reports that we included, correct?
Talking about, I see text messages from May 17 as
Correct.
the last date.
Okay. I heard there was something earlier about Ms. Gilmore had a potential issue of you not receiving something, and I just wanted to make sure that all the information has been reviewed by the court. So I wanted to verify.
And
17th is the last date.
did Your Honor also get a bench copy of the nail? They just came in yesterday, the nail results. They were all negative.
I did see that.
Perfect. All right. Thank you.
All right, go ahead.
So there's obviously a lot here, and I will try to limit what I am saying here. As much as I'd like to give a PowerPoint presentation, given the volume and complexity here, I'm going to try to limit my comments, avoid the uncorroborated statements from either side, admittedly, and focus on what the court can conclude based on corroboration of documents, professional witnesses such as Ms. Fellows, or admissions or inconsistencies by the other party or those on their side. While Ms. Ouellette wants the court to reconsider her misrepresented account of Mr. Agovino's history, which she has raised for the fourth or perhaps sixth time at this point, and provides nothing new that the court has not reviewed, made decisions on, crafted a parenting plan around, we are only here because of Ms. Ouellette's out of control behavior in both February and April. I want to start in February, and I'll just go through things as concisely as I can, given the circumstances and the nature of things. February 14th, or perhaps the 13th, that's when it starts. These events would be grounds for mental health evaluation, anger management evaluation, and a revisiting of the parenting plan in itself. Mother's behavior was completely unacceptable under any circumstances, yet she continues even in her most recent declaration to dig her heels in and paint herself as a victim, in contrast to her claims that she's accepting responsibility for her errors, such as alcohol relapse. It is worth noting that the day before the visit, Ms. Fellows reminded her of the protocol for visitation the day before, because Ms. Ouellette's father or someone else would take the children on many days. The day of the visit, Ms. Ouellette did not follow the directions. She parked in the wrong location, had one of the children knock on the door, not once, but twice, even after told that this is not the protocol and the children need to wait in the car. Then in front of the children, Ms. Ouellette gets out of the car and screams at Ms. Fellows about the visit being late and how, quote, in her words, inept they are. Beth was the parent here and protected the children from this, said not in front of the kids, and scurried the kids inside so they were not subject to screaming from mother towards Ms. Fellows. After Ms. Ouellette returned to the car, she yet again returned to Ms. Fellows, continued yelling, saying she is not doing the visits anymore. Beth wrote in her email to both attorneys and the court, I'm sure the court has reviewed it, quote, it was clear she was furious and didn't care, end quote, referring to she was behaving this way in front of the children. Mother then wrote in Beth's words, a scathing email, end quote, blaming Ms. Fellows for what amounts to following the protocol that she reminded Mother about the day before, blaming Beth for, quote, intentionally creating problems, that's Ms. Ouellette's quote, end quote. She again expressed that she will not continue working with Beth as a supervisor. Beth then texted Ms. Winkles, and Ms. Winkles informed Beth a new piece of information that was never informed to Ms. Fellows. That Anna, but she also
object, Your Honor. At this point, we're now having hearsay, which I objected to in the pleadings. We're having what Beth Fellows said, what I said. Neither one of us signed anything under penalty of perjury, so this is all hearsay.
Mr. Roberts?
Can I continue, or do you want a response?
Well, I want a response.
Well, this is all information, Ms. Fellows' declaration. Ms. Ouellette is free to contest whether that happened or not.
There is no declaration there is no declaration by Ms. Fellows.
I misspoke. The rules of evidence for these proceedings allow relaxed standards. The court can consider this as it finds appropriate. I think it is enough for the court to consider, and I can move on.
So the court is finding it is hearsay at this point. I do not have a signed declaration in regard to this. There's no reason that couldn't have been done to say relaxed rules still apply. So with that, at this point, the court is not considering it. So with that, other than a general that there was an issue, the details and who said what is not going to be admitted and considered. Go ahead.
Mr. Agovino provided his GPS data to Beth and also to Ms. Winkles. I provided that in Exhibit 5 of our declaration with an offer to provide more upon her request. My email was attached. There was no request that followed. Ms. Ouellette simply wants to muddy the waters by including a part of the app's website that essentially says, The app is not 100% accurate because a person's phone may go offline, but we have enough in the records to conclude the app data show his location. Miss Ouellette is not providing any information to show that is not true other than her uncorroborated accusations. And Ms. Fellows viewed this and found there was no issue. These events of February 14th show that Ms. Ouellette will simply stop at no end to cause destruction to those that she does not appreciate and does not like, and destroy Bill's relationship with the children and get him arrested on that day. In April, she was arrested, and the day before the arrest, there were texts to Josh that stated, "Call me now or this won't end well. Call me now or I'm about to burn everything." The court has those text messages. The court also has that in the police reports from the incident. The next day, there was vandalism of Josh's car, including throwing items off the balcony, breaking some of them. The video shows that Miss Ouellette was alone in the car for about a minute. No one else was visible in the vehicle, but Miss Ouellette continues to blame a drug dealer for the fire with what is an impossible timeline. She and her father swear under penalty of perjury that the police have video of who lit the fire. Matt, her father, claims to have seen it and claims that is why he believes Anna is innocent, because he would not support his daughter if she was guilty. That was the implication, if not the explicit message. He refers to this video, but the police reports show that the only video that they have available was a video of Miss Ouellette in the vehicle alone for a minute, and the only other person in the vehicle, a male, was Cheyenne, who, according to Deputy Rutherford, asked Miss Ouellette what she did when he saw the fire was taking place, to which she responded, "I don't know." Cheyenne, Mr. Howard, is a material witness to the crime and possibly a co-conspirator. Anna's statements to the police were inconsistent, perhaps most notably about her injury, which the police noted did not line up with either the photographic evidence or her other statements to either the same police officer earlier or other police officers with timeline. Miss Ouellette told Deputy Yeager that she hopes his daughter gets abused and raped, that she threatened to find him where he lives and, quote, get him, end quote. She said she would drop the charges against Josh if he dropped them against her, showing that her accusations in her big talk was nothing more than attempts to protect herself from prosecution. The police clearly did not find her credible, as this was laid out in the reports, and Josh was therefore not arrested, almost certainly due to this reason of her statements being inconsistent and the evidence not lining up with anything she was saying. Her behavior indicates a profound willingness to say anything to harm those to whom she harbors ill will, and echoes her behavior in February. Even if her accusations were true, none of this is a defense to vandalism and arson, nor does it excuse what happened in February. Soon after she was released, she was arrested for a no contact order. I understand there's some excuse or some bickering about that issue. Nonetheless, she was arrested a third time, which she appears to indicate, and I believe her father's declaration also admits she was driving under the influence of Xanax, as if that is as if having a prescription is an excuse. It's a drug that is indicated that you do not drive under the influence. This incident corroborates the other statements from Josh and Cheyenne that she drove intoxicated with the children in the vehicle. Miss Ouellette claims she did not know of Josh's criminal history until her attorney informed her of this after her arrest. This is entirely inconsistent with her statements to the police, where she stressed that Josh was a felon, and this was from 18 years ago, by the way, but I'm not painting Josh as an angel, but it's immaterial here. He has no misdemeanors from the past 10 years as well, for the record. But she stressed to the police he was a felon who has, but should not have access to her multiple firearms. She also takes it upon herself to claim there was a non-disclosure agreement in Bill's prior divorce. She provides no evidence of this. It is entirely false, but it is yet another example of what appears to be her relentless willingness to claim, without any evidence whatsoever, something simply designed to harm Bill in the eyes of the court, muddying the waters sufficiently to where the court just doesn't know what to do. With respect to firearms, Anna swears under penalty of perjury in her declaration she has no firearms, but multiple firearms were revealed in multiple locations to police, under her bed and in her closet, both of which appear to be stored in ways that could easily be accessed by the children. She said that, quote, anyone, end quote, could break the lock, I believe it was, she said, under the bed, meaning these were not safely secured in a house of two children. With respect to her alcohol use, she claimed 6 years of sobriety until one bad month. Matt seems to back this up as well, with 1 month out of 6 years of sobriety. This is simply untrue. Her bank records show consistent alcohol purchases from 2021 to 2023. We don't have her most recent bank statements from the end of 23 until recent, but I think the court has enough in front of it. She is simply making claims to the court to muddy the waters when the hard evidence shows that she is not being candid. She also curiously ignores in her reply declaration the vial of LSD, which was found in the freezer. While I am not looking to do any work for her here, I'm sure she would like to blame Josh, but it begs the question why Josh would ask the police to destroy drugs that he kept, that were his and he wanted, when he could have just kept them and no one would have been the wiser for it. Mr. Howard has been dependent on the Ouellets for years. He claims to live in a separate address to the court under penalty of perjury when there is a motive for this to be true, but he tells the police that he lives with Anna when there is no motive to lie. Circled that part in the police reports. His address was the same as Josh's, the same as Anna's, indicating that as recently as April 15th, he was living with her, despite claiming otherwise when it is convenient for the Ouellets. He wrote an email, which we submitted, admitting to facts that establish thousands of dollars of child support fraud, but then tries to walk it back and said he was paid for watching the kids when his exact words, without any caveat in the email, were, quote, handed directly to Anna, referring to the money. Anna's father, Matthew, he's the reason Anna is not homeless and continuously on drugs or in jail, as far as the record shows. He has sheltered her and protected her for years, and we can simply only speculate what else he's been hiding over the years. Not only did he lie to the court about having and seeing a video showing the perpetrator of the fire, which shows Anna in the car alone for a minute and Cheyenne being the only other possible suspect, but he was also evasive and slow to respond about the whereabouts and well-being of the children in the aftermath of her arrest. He refused to answer any questions about whether the children would be living under the same roof as Anna after her arrest, or whether she would live in another residence on their property, which is a central issue that no parent under any circumstances should be deprived of knowing, but he did this to Bill. He claims Bill is one of the most violent people, end quote, he has met, but provides not a shred of evidence of violence, nor is there any evidence of actual violence in the thousands of pages that Ms. Ouellette has put in front of the court at this hearing and multiple other hearings, showing that he was arrested for anything other and convicted of anything other than harassment, other than her uncorroborated accusations. No injury, no arrest, no police report showing physical contact, violence, etc. It is clear that Mr. Ouellette values protecting Anna over what should be his obligations to keep Bill, the father, informed about the children. Bill has been candid with the court since the beginning of this case about his criminal history. He has a harassment from 2018. There's nothing in his record violent, despite the ongoing claims that he has a pages-long rap sheet, as in the most recent plea filing from Ms. Ouellette, that's never been provided to the court, but she keeps barking up the same tree and crying wolf about violence, 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 without providing anything for the court. On April 23rd, it is worth mentioning the kids struggled more than they ever had, and Beth had to intervene with the visit. We provided the email. We can only guess what the children are going through in the privacy of their own home due to the direct and singular actions of their mother. The fact of the matter is that Miss Ouellette cannot support herself, let alone the children. She's been living with her parents exclusively for the past many years, except for 2 unstable periods, one where she ended up in rehab, and the current situation where she currently has 3 arrests, threats to police to harm their children or wishes to harm their children and their families. If this were a guardianship case, which has not been filed, we would be talking more about her parents, who seem to be the only reason why she is housed and the only reason these children can possibly be safe under any stretch of the imagination. She appears to be almost exclusively cared for by her parents and cannot parent the children without significant outside help. She's also currently facing a serious felony that may result in substantial jail time. This is beyond any claim that this is a village raising the children, but is rather a situation where she is not capable of supporting herself or the children without the supervision, and yes, supervision of her parents, not just their assistance in the way that grandparents do. I would invite the court to just imagine if Mr. Agovino were the one on the opposite side, if he were the one that acted this way in February, if he were the one with these arrests, there'd be a very different presentation than what Ms. Ouellette is asking the court to do. There's simply no argument that she can provide to show that she can care for the children or has cared for the children for the past several years without her parents involved, both financial and social. It's simply the case that we are here because Ms. Ouellette has proven herself at multiple instances in 2024 of being unfit to care for the children, all while trying to get Mr. Agovino arrested and harmed in the eyes of the court for fabricated charges of reconnecting families and lying to the court about the events in April, lying about the status of her firearms, lying about what happened on the date of the arrest, and that she was 6 years sober. In conclusion, I would ask the court order a mental health evaluation, an anger evaluation, a domestic violence evaluation, a substance abuse evaluation, and that the court order random testing for alcohol, drugs, and marijuana. I'd also ask the court to grant attorney's fees. This case simply would not be here, but for the sole and singular actions of Ms. Ouellette, and there should be some compensation, regardless of the nuances of the court's outcome or the court's decision. Thank you.
Ms. Winkles?
Yes, Your Honor. It's a lot to break down, and it seems really horrible. But when we look at this case, we need to start at the background. So Mr. Ouellette, Mr. Agovino, which we have filed, has findings of domestic violence. We've submitted information showing injury, and this is past stuff, but it becomes really important. My client was injured by him, was in treatment and hospital treatment. These parties were alcoholics. Mr. Agovino never got sober. He would start treatment, finish it, or not finish it. He'd start treatment, leave, start treatment, leave. That went on until about a year and a half ago when he was arrested for driving under the influence. And then he was given an option, go to jail or essentially finish the treatment. That was the first time he finished. So when we start this, we need to see that any of these claims of just being harassment, you can see his probation officer's information in the file. We also submitted it again, which clearly states that he's violent, that he's aggressive, that he is engaging the children in this violent aggression. You can see all of that. That's Mr. Agovino's past. If we look at Anna's past, up until then, she was an alcoholic. She went through treatment. She did have 6 years sober. She does vape. She does buy her vapes at Boondocks. That doesn't show alcohol. What we have are 2 alcoholics. Both eventually went through treatment. My client first, Mr. Agovino later. We look at the DV. Now they're requesting all of these evaluations, and it's interesting because Mr. Agovino, when Judge Evans was before the court, made significant findings in the parenting plans against Mr. Agovino, and it stated that he must have an evaluation of a certain sort in the state of Washington. He's never done that. He's never done that. He's never completed it, yet he has a history of convictions of DV. My client does.
I'd object. There's a DV harassment. There's nothing else that's been provided that needs to be central in the court's analysis. There's a DV harassment. It was nonviolent, and that was the only conviction.
And we have his conviction history before the court, and that's on the Oregon sheet, which is updated. It is more than one thing.
I'll look at the sheet. Hold on. I'll look at the sheet that's been filed and leave it at that.
There are probation violations, nothing violent, and no new convictions.
And the probation violations were for further harassment and DV.
Harassment, not violent, exactly.
Am I going to get to talk here?
Mr. Roberts, I've heard.
I apologize. I just wanted to clear the record. I will.
Okay.
I'm done.
All right, Ms. Winkles, go ahead.
Okay, so we start off with that. We start off with 2 alcoholics, one that has a significant DV history, one that doesn't. We then have both of them eventually going through treatment. And my client's was 6 years ago. Mr. Agovino's was recently. We then have my client admitting to falling off the wagon. And this happens. Relapses, unfortunately, relapses are kind of a thing that happens. I believe in treatment, they say it's not if it's going to happen, it's when. What did my client do when the relapse happened? Well, let's look at the good things she did. She immediately went into treatment before any of this ever started. And you'll see those records. She goes into treatment with I can't remember my brain just went dead. She went into treatment immediately, ideal options. She then gets a Vivitrol shot, which makes it so that she's sick if she ever drinks. She then tried to get a nail test. And unfortunately, she had acrylics on. They took those off. She waited for her nails to grow. But in that meantime, just to make sure that the court didn't think anything funny was going on, she takes a UA. The UA shows that she's clear of everything, including alcohol, because this is actually after the arrest. We then look at the nail test, which you can't get around. Didn't know we did that in this county. Did the hair test or the nail test. It comes back completely clean of everything as well. This shows that what my client is saying is true. There's no drugs. There's none of these drugs. And if there were drugs, it's Mr. Higgs. And we'll get to that in a second. So she enters treatment immediately. She also enters treatment for being the victim of DV. So if you look at Mr. Agovino's history and you look at Mr. Higgs' history, they're very, very similar. My client leaves one abuser and then enters a relationship with another. This happens with DV victims. It's unfortunate. My client has been informed of this. She has entered herself into counseling, behavioral therapy, cognitive treatment in order to get the toolkit and the skills to rewire her brain to make sure that doesn't happen. My client has no issue with the court ordering, no do not introduce these children to any new romantic partners for a period of 6 months, that my client has to continue this counseling, this PTS treatment, and all of that. She's done the evaluation, essentially in mental health, when she did her intake at the women's support shelter. Now they throw this red herring in of Beth Fellows and that February visit. They didn't file anything in February. Nothing was filed. What occurred was my client believed she had a restraining order and she wanted the children. This is not, she normally doesn't do these drop-offs at these visits for the fear of running into Mr. Agovino. It does trigger her, does cause her to cry. So she did knock on the door. She probably went outside of protocol, who knows? But her concern was being in front of or around Mr. Agovino. She claims that he flipped her off and that he was aggressive, which triggered her. He's saying he wasn't there. I don't know of any GPS service that can pinpoint somebody where they're at within 10 feet of each other. I believe Mr. Agovino says he was at the back of the building. My client says he was at the front, or vice versa. I'd be amazed if a GPS could show that, but in any event, we just have two differing stories. Nothing here is crazy. Nothing here is violent. You have two people who don't like each other that are trying to avoid each other. That's it. It's nothing more than that. The issue is this, what happened in April? And that is what they're hanging their hat on here. My client got drunk. The children were not there. They were at her father's house. My client got drunk. She did something she shouldn't have done. She gets arrested for whatever it was. Now, they keep mentioning this video. Well, the still shot on the reply declaration is from that video. That video is in existence. Did the police have it at the time of their arrest? No. Do the lawyers have it now? And so any of the statements made by Anna and her father come from the video, which I supplied a screenshot at Exhibit A and Anna's brief reply that just says, here's a screenshot of it. But whether or not it even occurred, it doesn't matter, in a sense that it was a result of substance abuse, alcohol. My client identified the cause of that, alcohol, and immediately sought treatment. She made a mistake. Absolutely. She fully admits that she made a mistake, and looking back on it, she realized it could have ruined her entire life and her children's lives. Did she drink with the kids in the car? No, there's no indication of that, and just throwing that in there doesn't mean it's true. She relapsed. She got back on the wagon. She's more committed now than ever about continuing. She got Vivitrol. There's no way this woman can drink unless she wants to be vomiting all the time. Now, what happened that night? They want to make my client seem crazy, and that's generally what they do with DV victims. But if you look at Mr. Haig's criminal history, he has more DV, and they say he doesn't have any felonies. That's not true. You can look at his watch report. The man has 3 felonies, and all of his crimes are either drug-related or DV-related. So when they say these aren't any of his drugs, why would he leave them in the fridge? LSD, maybe he forgot the LSD was in the fridge. My client has a clean nail test, clean UA. Mr. Haig, on the other hand, has multiple convictions for possession of drugs and drug dealing. The fact is that's how the fight started initially. It started over her catching him using cocaine. And then what we see is we see her attacked. You see the black eye. Now they want to say that Anna did this to herself. I think it would be a rare person indeed that could punch themselves in the eye from the other side. I'm not sure how her injury was inside next to her nose, if she's the one punching, because it wasn't this one, it was this one. So it would be very difficult, the way her black eye is, for her to have done it herself, especially looking at that man's history of abusing women. We then have his first wife, who writes a declaration stating he is violent, he's scary, get a protection order. My client goes and gets a rape test and a protection order the night of this incident. She was granted, after a trial, the protection order in this court. To blame the victim and say, well, she got arrested for this. Well, unfortunately, this happens a lot. The time of arrest, they arrest the victim. It happens more often than not. It's usually sorted out. And that's where we are now. Her lawyer in her criminal matter is taking care of that. The no contact order. This shows Mr. Haig's intentions here. You have a no contact order that doesn't have the residence listed. It just says Mr. Haig's residence. She gets a call telling her that he's moved out. She goes over there to collect her items and suddenly is arrested. Those were dropped because the protection order didn't say the address, and he had moved out, and he confirmed that in those records. So, I mean, to use that is frankly ridiculous. The driving. My client was prescribed Xanax, as you'll see from her file on 4/18. She was arrested 2 days later for driving on Xanax. So unfortunately, Xanax has a half-life of about 8 hours. So she either, essentially what they're saying is nobody has ever taken a Xanax and then driven later. That's not true. We all know that's not true. Now, was my client smart to do it when she was new to the drug and did not know how it would work on her? No, absolutely not. And she fully is aware of that. Those charges have been essentially all but dropped. It moved to something that's just a ticket. There were no children in the car at that time. Josh being in prison, the firearms being Josh's is a problem, which were reported in that to the police. So to say that my client had all these guns when it was Mr. Haig, and whether or not my client even knew they were there, we don't know. Cheyenne claiming to the cops he lived with Anna at the time of the arrest. He's the nanny for these children and is with them for 1/4 of the time. The rest of the 3/4 he's at his girlfriend's, and he lives with his girlfriend. I think he could kind of say either address is appropriate, and not everybody tells the police probably everything when something's crazy is going on. And here's the thing, they're claiming that my client has lived with her father the entirety of this. That's not true. She lived in a duplex with Cheyenne, which he talks about, and you can clearly see that she lived in a duplex when the matter started. She lived in a duplex with Cheyenne for years and years and years. Cheyenne would get the check from the state or from Bill and pay Anna the rent, which is exactly what he states in his declaration. Interestingly enough, they try to say that he made all these statements, but you clearly see a history between Mr. Agovino and Cheyenne of animosity. So suddenly Cheyenne out of the blue is just verbally vomiting all this stuff to Mr. Agovino and his wife, but there's no record of it and it's just out of the blue. That seems very odd that somebody would do that, especially somebody that's now written a declaration saying no, not at all. Living on her father's property. This is an 8-acre parcel that has two buildings on it, essentially 2 homes. It seems like a better idea, and frankly, just better for everybody, for Anna to live on the property of her father. Why? Because it's reduced rent. Why? We have childcare right there. The children can go see their grandparents at all times. This is a great thing. It doesn't mean that Anna can't take care of herself. She clearly has a job. She clearly, is working. She's had a past of working. She lived in a duplex with Cheyenne for years and the children were doing great. But the fact is that any single mom, when you have your parents there, that's only a blessing. And who it really is a blessing for these kids. And I think that is the crux of the issue here, is that we need to look at what is in the best interest of these children. And right now we're throwing mud at the parents. And the best interest of the child is really the test here. And so let's look at them. These children have not lived with their father since prior to 2017. And in fact, they had very, very limited contact with their dad from 2017 to 2022. It's all but abandoned. They were with their mom that entire time in a duplex with Cheyenne. They have a very close relationship with Cheyenne and Grandpa and Grandma. So then in 2022, Mr. Agovino comes back saying, I want visitation. Well, from the years 2017 to now, Mr. Agovino has had all of 9 in-person professionally supervised visits. That's it. These kids know mom. Mom is there every day. Grandpa is now there every day. Grandma's now there every day, and Cheyenne's now there every day. That's their support system. On top of that, they have a school. They go to St. Rose. They go to a Catholic school, a decent school, and they're both in, as you can see from the daycare sheets, a significant amount of extracurricular activities. Kids have something every single day. What's in their best interest? Well, mom is now stabilized. She now is on Vivitrol. Her relapse of a month probably traumatized them. I'm not going to lie about that. Sure it did. But no more than having their dad abandon them, no more than this litigation, no more than anything else that will happen to these kids in their life. But what we have is a mom who's stable again, after a brief relapse, took control of it, took care of it, is in a safe place for these kids, nowhere safer than Grandpa and Grandma's property. And it's a farm. It's an 8-acre farm, and they have their own home. On top of that, we have a nanny they know. We have schools and friends that they know. And there's no risk of immediate danger to any of these kids. We have the protection of the grandparents. More than that, we have Anna in counseling for a number of issues, and we have her in treatment already. If they were to be removed and allowed to go home with Mr. Agovino, he hasn't even moved out of professionally supervised visitation. And he hasn't done his DV evaluation. He hasn't done anything that this court asked him to do under Judge Evans' orders. He has only had about 7 visits in the last 5 years with these kids. They've never been to California. They've never been to school there. They have no friends. They have no family that they know. They do not know Mr. Agovino's family from iota. It would be so incredibly traumatizing to them that these kids, it wouldn't just be a day of misbehaving like Miss Fellows apparently said. It would be a fundamental shift in everything we know, or everything they know, and would traumatize them probably till adulthood. In this case, my client is doing what she can. She shouldn't be punished for fixing it. If she hadn't taken stock of it, absolutely, but she has. So we'd ask Your Honor to leave the orders in place as they are, to deny their request. And the child support, I'm not going to argue. They don't have a motion for that. Really, it would be my client's motion for contempt. Thank you.
Mr. Roberts?
So I'll go on there was no request for child support. It was just showing the situation here. But I'll go through my points and we can wrap things up. So the court can review the DV findings, but my client's position is that there's never been a finding of any domestic violence. There was a DV harassment, and that was the conviction in 2018. My client admits the behavior that took place on probation. He's far from proud of it. He put me that clear in his declaration. This was when he was still struggling with alcohol. However, he completed outpatient treatment, 12-step program, as he explains in his reply declaration, and he's been sober for significant periods of time. He's taken naltrexone shots now. He's simply not using alcohol, and there's no concern. There's been no issue with him whatsoever for 3 years, which is why there has been nothing that has come back to court to show. There's nothing been in the record for the past several years, since before this case was refiled in Washington from Oregon, to show any more recent issue. He did inpatient for 120 days, I believe, and that was in his declaration. I was a little unclear about, her test being clean and right after the arrest, et cetera, but then she did admit to drinking, et cetera. I mean, if she took the test immediately after being arrested, I was a little unclear from what Ms. Winkle said. I'm not sure it's the biggest deal, but I mean, the fact of the matter is, if her behavior is alcohol induced, then we have an alcohol problem. If her behavior is not solely related to alcohol, which I don't believe the record shows that it is, then we have an additional issue for mental health evaluation, as well as anger. The court can see the lashing out. It is not simply a slip up to tell a police officer that, I hope your daughter gets raped and I'm going to find you and look up your house and get you. I hope that Ms. Ouellette can gather the skills from whatever treatment she's going into. Going on DV victim treatment, maybe she needs it, but it's also a self-serving thing to do, to say that I'm here because they arrested the victim. I don't think the record shows that they arrested the victim. Ms. Ouellette admits to the vandalism in the police report. They did not arrest the victim. They arrested the perpetrator who confessed to the crime of a vandalism, and then just minutes later there was a fire. The screenshot, it looks like, from what I'm looking at in the declaration, where there was a screenshot that Ms. Winkles points to, it's a picture of the vehicle with no male in it whatsoever. I haven't seen this video. I would certainly request the video, but let's just go with the screenshot. If it's what I'm seeing that they filed, it's a screenshot without a male involved. If I was going to provide this court with evidence that there was a male involved that was not Cheyenne, the screenshot would include a picture of a body, not just the vehicle itself, showing that the build is not Cheyenne, that it is a male and not Miss Ouellette. I don't see that, so I can only infer that that is simply not the case. With respect to us not filing anything in February, we were in settlement negotiations. I'm not going to get into the details of settlement negotiations, but we're trying to let things go. I mean, my client puts it in the declaration that he had some serious concerns, but he's just trying to get more time with the kids. And he was going to let that go until the significant problem in February escalated to even more significant problem in April. And I think Ms. Winkles mentioned that she doesn't know any GPS that can pinpoint location within 10 feet. We're talking the front and back of a building that's more than 10 feet. I don't want to presume the court's understanding of how much the court uses GPS in finding a friend and things like that, but my experience with GPS, whether it's Google Maps or whatever, is If I'm in front of a building or behind a building, it is right every single time I am not in the woods. I know that's not documentary evidence, but GPS is accurate when it is on. Ms. Winkles also mentioned that Ms. Ouellette may have gone to the door to knock. It was the children she sent there. With respect to her not drinking in the vehicle, I acknowledge there's no hard evidence of this, but the fact that she would be arrested for having Xanax and driving under prescription of a medication that got her arrested, I understand that diversion happens, and that's a good thing. I agree with that. However, the fact that someone is arrested for being intoxicated by a prescription drug, whether the kids are in the car or not, indicates a lapse of judgment about what they do when their mental state is not appropriate to drive. I did not say that Josh doesn't have any felonies, so the court can review his rap sheet as it wants. What I said is, at least from the report that I'm looking at that Ms. Winkles filed, maybe there were inconsistent pages, and I'm looking at his felony was from 2004, and his last misdemeanor was from 2014. Again, he's not a hero. I'm not trying to make him out to be some angel. The relevant pieces of what he speaks to that I'm asking the court to consider are corroborated by Ms. Ouellette's text messages of "call me or I'm going to burn everything down," the subsequent fire that happened the next day, and her statements to the police admitting the vandalism, the officer overhearing conversations, etc. We don't need Josh to be credible here to have those facts established, frankly, beyond a reasonable doubt, although it's not the standard here. With respect to the drugs, Miss Winkles mentioned that Josh maybe forgot the LSD. However, it was in the freezer, and therefore the police got to it. He found it, and it is an exhibit that he said, "I found this in the freezer, and I called the police to come get it." It was an affirmative act that he took to destroy the drugs that were there. And LSD, as the court knows, is not something. It's got an extremely short half-life, and most tests don't even test for it. I'm not even aware of a test that will test. I'm sure you can test for it, but the 10, 12, 15 panels don't have LSD on it. With respect to the firearms, Ms. Winkles, if I understand her correctly, she was implying the firearms may be Josh's, and we don't know if Anna knew they were there. The police report makes it clear Anna is referring to in multiple locations, and it appears to be multiple times, because at one point in time, she mentioned firearms under the bed. And at another point in time, she said, "Oh, there's also a firearm in the closet." So she affirmatively told the police she knew where multiple firearms were, and claimed that Josh should get in trouble for them, all while claiming to the court here, under penalty of perjury in her response declaration, that she didn't know anything about Josh's criminal history. Why would she be telling the police this felon shouldn't have access to the guns under the bed or the guns in the closet if, one, she didn't know he had a criminal history, including a felony, and two, she didn't know the firearms were there? The court can conclude, and all reason indicates the court must conclude, that she knew he had a felony, she knew about his criminal history, and she knew that multiple firearms were in the home. There's no other way around that. But she tells the court a different story because she is trying to trick the court here. With respect to Cheyenne's address, it is not appropriate for a person to give their address to the police as their work address, period. That is not a justification. Cheyenne told the police he was living there because he was living there. I have never told the police when I said, "Give me your address," my office. Never happened and never will. Father's property is large. It's great. It's great to have grandparents involved. We all agree. Why did she move into a duplex with Mr. Howard if that place was so wonderful? Why did she move out and go to rehab the first time? I'm not doing this to be cruel. I'm doing this to illustrate the point that if that is the ideal situation, she has moved out multiple times, and both of those times have resulted in danger. And that's the central concern in this case, of what capacity is there, not an ideal situation of having grandparents around. I think that's great. And I would love for that to continue if it was a stable situation, but we don't have that information in front of the court that is in fact what's been happening and that she can parent appropriately. Ms. Winkles mentioned she got a new, she's employed. I know she got a new job at the beginning, I think it was the beginning of 2024. She was unemployed for a significant period of 2023. And I'm curious if she is still employed after this arrest. I don't have any new information. Nothing's been provided to the court that she has been working since then. My client has been, it's true that he has supervised visits at the moment. The children were born in California, lived in California for the first few years of their life until 2016, 2017, when they relocated. With respect to the DV evaluation, once again, my client was had that queued up, but there were settlement negotiations.
I'm going to object, Your Honor, to anything that that talks about settlement negotiations in any way. It's not appropriate.
And this is simply to go to why, if they're opening the door to why he hasn't done something, the reasoning is there were conversations about not
conversations is hearsay as well.
Oh, okay. Oh,
it's a different purpose than. Sorry, Your Honor, go ahead.
I do not want to have settlement negotiations entered into this argument here. Bottom line.
Okay, I'm not going to belabor the point, but I do want the record to reflect there was a good faith reason for it. But now that we are here, it is going to happen. There were some issues, and even the GAL couldn't point him to a proper DV evaluation because of his status in California. There was a significant confusion. I know Judge Evans was on this case for a significant period of time. So just to bring the court up to speed, since it may be relevant, is that there was a DV evaluation done. It was done. My client was trying very hard to get an evaluator that would deal with it in California. The GAL didn't have any recommendations. Olivia Lovely was at a dead end. So he found someone in California that everyone seemed to think was going to be successful in terms of being an evaluation that would qualify. And then he filed the DV evaluation. Ms. Winkles then came on the case kind of right then. There was a switch of attorneys, and I'm not drawing attention to that other than like giving the court the timeline. And then Ms. Winkles pointed out some discrepancies between the DV evaluation, how it was conducted in California by a California licensed professional, and how that isn't per the Washington guidelines, which put Judge Evans in the position where he said, okay, I'm increasing visitation, but I am going to make you get another DV evaluation per the Washington guidelines, which has cost my client thousands of dollars. And that's part of the delay here. But it'll get done because here we are. If the court's so, with respect to the in-person visitation, the visits are going very well. Ms. Fellows has done nothing but communicate how the visits are going incredibly well. The kids have a great relationship with the parent, with the father. I would just mention that the kids had extremely hard visitation on April 23rd.
I'm going to object again to anything that the kids are doing or anything like that, but Ms. Fellows has not put anything before this court.
Well, my client, it's in my client's declaration as well, outside of Ms. Fellows' email. So anyway, that's all I have to say, Your Honor, and the court can take it how it's going to take it. With respect to the payments for rent, Cheyenne said he would, I have to mention, although this is not central to the issue here, Cheyenne didn't say he would pay her the money for his rent. You can look at the email. He said she would use it for her expenses. That was directly in his email, and now he's walking it back. So I think that covers pretty much everything here. We didn't put it in the motion for immediate restraining order, but I think it's an appropriate consideration for the court to, if the court's not going to grant everything in the restraining order and the evaluations, et cetera, I would ask the court at least to modify the parenting plan. My client has, in some sense, appreciated the supervised visits because the incident that happened in February would not have been provable if there wasn't supervised visitation. But I would ask the court for increased parenting time if the court's not willing to grant the full request in the client's motion.
Just a brief response, Your Honor, very, very brief to that request.
Extremely brief.
Dad's DV evaluation was done by a real estate agent. It didn't include anything that is necessary in a DV evaluation. It just said how great Dad was, didn't look at his criminal history, which is required, didn't have any mandatory findings, which are required in Washington. It was done by a real estate agent. That's why he had to go get another one. And the fact is because of that, Judge Evans was very clear until you get because of his massive criminal history and probation violations and all of that as recently as 2021, Judge Evans was very clear until you have that, no increased visitation. To use Anna falling off the wagon is the reason why Dad is somehow bumped up. Looking at good best interest of the children. Dad doesn't get bumped up because Anna falls off the wagon. Anna goes down, Dad remains where he's at, which is professionally supervised visitation. We found the evaluator, he just hasn't done it. He needed to bump himself up, he has to bump himself up, not lower Anna. That's not how it works. Thank you.
Yeah, I want to briefly mention about the DV evaluation. The DV evaluation was done by, I have the report right here. It was done by just want to make sure she's a PsyD, so she's got an advanced degree beyond a master's degree. She also does real estate on the side. That is a thing in California where doctors will do that. I'm not disputing that she does real estate, but she is not a real estate agent masquerading as a doctor. She's a doctor with real estate agent work on the side. It also needs to be mentioned that when this DV evaluation, of course, was supposed to consider collateral information from the mother, and when they pre-scheduled their phone call, mother didn't want to talk. She didn't give her any information whatsoever, which I interpreted then, and I still interpret now, as a unwillingness to even engage in it and wanting to then attack the report after the fact. I'm not disputing that it was perfectly in line with the Washington requirements. That's not the issue here, and I'm not putting that as an issue here. But the fact of the matter is, Miss Ouellette did not. I forget the language she used, but she said something like, "I'm not comfortable talking to you about what happened," which this is the point. She requested the mental health the DV evaluation. And then when given the opportunity to do so, she doesn't say anything, but then writes a scathing declaration about all the things that it would have been great if she told the evaluator. And the evaluator ended up saying there wasn't any DV issue because mom didn't tell her anything. So that's all, Your Honor. I had to address that.
All right. So based on the files and record, the court is looking at two parents that the court has significant concerns about. Both of them, not one of them, both of them. And looking at that, the question is about what is the best interest of these children, and trying to weigh the negatives that I see on both sides of this. I went back and I looked at the temporary order in which Judge Evans, I believe, had ordered the temporary parenting plan back on November 3 of 23. And looking at that in regard to, there was a finding on domestic violence for the father. And it says has a history of domestic violence as defined in RCW 7.105.010. So that finding has already been made. A finding of neglect by the father and neglected his or her parental duties toward a child, listed in two being the two children, Alyssa and Aaron. And noting the ages at that time, anyhow, Alyssa was 8, Aaron is 7. So when you talk about, well, they lived in California and they were born in California, that kind of contact, looking at the ages and when that would have occurred, they would have been extremely young. So now we're looking at children around 8 and 7, maybe a little older at this point, obviously with the dates, but that's what the court is going to consider. So the court also has significant concerns in regard to mom and what happened, the allegations, understanding their allegations, those will be litigated in the criminal process if that is what's going to occur. And so looking at what has been said and weighing what went on there. So that is the question at this point is, again, what is the best interest of these children based on those two scenarios? And at this point, given the age of these children, the court finds that it is only appropriate to maintain them here in the state of Washington with a number of limits on the mother. And in regard to the request for the protection order as outlined, let me get back to that here. So on April 30, 24, there was an immediate restraining order that was entered. And looking at that and what is or isn't appropriate, the court does not find at this time that any of the requests are appropriate. That again, at this time, so the request for the restraining order is going to be denied. However, again, looking at the mother and the part that the court did talk about, which is only appropriate. So the request for the children to move to the father, as I said, is denied, but on the conditions that the mother is not to consume any alcohol or non-prescribed drugs or marijuana, nor drive a vehicle without having consumed any of those. that the mother, it sounds like this may already have been done, is to obtain a current substance abuse evaluation and treatment as requested, that she is to not, as I said, consume the items as indicated, that she is to have random UAs. And the question is how to best do that. Typically, I would have the other parent make that request. But because the father doesn't reside here and doesn't have regular contact or that type of scenario that I would usually do that. Counsel, do either of you have any suggestions of how to do random UAs?
Scott Roberts could email me, or just shoot me an email saying do a UA today, and I can tell my client to go get one. I mean, that would be the only idea that I'd have.
The parents are communicating. Well, the parents are communicating through third parties on the Talking Parents app. So, Mr. Ouellette, mother's father, has been doing the communication for her and apparently has business hours that he won't respond outside of, which I think is inappropriate. I think we actually should have an order ordering him to put that on his phone. I know he doesn't want it, but there needs to be a method where he can be communicated to at all times, because Ms. Ouellette is not going to be in direct communication with my client or my client's wife. So we need to have communication parameters set clearly so everyone hears it now, and it's in the updated order, because the issue of Mr. Ouellette saying, "Oh, I didn't get your message. It was after 5 o'clock on a Friday, and I don't check this app because I don't like installing it on my phone and I refuse to do so," is unacceptable. And I think that Ms. Winkle's suggestion is partially reasonable. I don't think my client should have to pay me to email Ms. Winkle's because mother's father refuses to be available during the day unless he's at a computer. I think they can
have any authority over the mother's father, no matter what.
Well, then sure, but then mother can be responsible for checking the Talking Parents app, having it on her phone, and communicate with my client's wife. If she gets the benefit of not being part of a communication chain, then she has to be held to standards of being available. You can't have it both ways. And we had a problem, and we need to prevent a problem from going forward, in my opinion.
So, Ms. Winkles, is there some reason your client won't have the Talking Parents on her phone?
In the past, they've harassed her, and that was one of the parole violations, and so that's the reason it triggers her. I don't understand what the problem is, though. If there's a UA that's needed and it's after 5 p.m., the place is closed, and the place is closed on. I mean, it's only open, but it's Performance Occupation, I think, is the place in town. I think there's also one at Quest. They're both during regular working hours, so I'm not sure what the after 5, why it would be necessary, unless they wanted her to go like at 8 a.m. in the morning the next day. But otherwise, if they text her or email me, at that time, then I can just tell her and she can go, as quickly as possible. But I'm not sure what the problem is to having working hours. It's, they expect him to respond, and like when it's, he's out, grandpa's out, doing something, they want him to respond then. It's not very fair. But that's the issue, is it's just triggering to her. I can speak to her. I can give her a text real quick, but my concern is that that's part of her growth through counseling, is not having any contact with him. So I'm not sure what to do about that aside from the attorneys.
If I may, this was before I was on the case, and it was, if it's 2021, it was 3 years ago. I can't comment on it beyond that. However, parents regularly communicate at 5:01 or at 7:30 in the morning, and we don't have circumstances here where my client should be prohibited from having any contact with the other side when circumstances warrant it outside of strict 9 to 5 hours. That's unreasonable. If something happens, parents communicate. So I think it's a pretty low significance request. If mother communicates with my client's wife or some other third party, and there is any inappropriate behavior, we're back in court for contempt, and all sorts of tools are at her disposal that my client has no interest in pursuing. But to say you have to pay your attorney to communicate a request at 5:25 because I didn't put on my phone.
This has been going on way too long here. So I'm going to order random UAs, that I am going to order that the mom have Talking Parents on her phone. It needs to happen. I get the abuse and the triggers. I get that. I need to make it very clear that the father and his wife are to only communicate for the sole purpose of scheduling, or I don't even know if that needs to happen. If something happens to a child, okay. But I do know if it goes beyond that and it's abused any way, then we'll be back here in court and looking at a contempt. So with that at this point, that's what I'm going to do. That's a condition of mom having these kids at this point. And so she needs to get it on there, random UAs, but they're random. They're not daily. They need to be reasonable. And so random UAs. And then in regards
Who pays for those?
What's that?
Who pays for those, Your Honor? Is it dad first and then mom reimburses if positive?
Correct. So at this point, I'm also requiring that the mom flat out not have any romantic parties. That at this time, with her going through treatment and everything that she's going to, that she's not to, as I say, have romantic relations. So that's going to be a condition of her treatment anyhow. So I'm guessing. In regard to the other requests, as far as the mental health evaluation, the court will go ahead and require that. I know it's probably more related to the substance abuse that happened, but I think a mental health evaluation and follow up with recommended treatment would only be appropriate and probably helpful to mom as far as that goes. So those are the conditions on the children staying here. Again, the children are here. They have limited contact with someone that's not been a part of their life. A move to California would be great upheaval to them, especially when people they know, the family and the school are here in Washington, and just weighing all the factors. That's the only appropriate thing for the best interest of these children.
Questions, Your Honor, or if you're ready.
Go ahead.
With both of the evaluations, substance abuse and mental health, couple questions. Collateral information from father, correct?
Yes, that would be appropriate.
And is there to be completed within 60 days or so? What do you want for timeline?
So as far as the timing, let me see. I want to try to remain a little consistent with the prior parenting plan. And I also know it takes time. So I'll put 60 days. It just takes time to get in. Like I said, I think the substance abuse has already been done. So I'm not necessarily going to change. I think she's been forthcoming on that. So as far as that part of it goes, the court will not be requiring input on that one. In regard to the mental health, that would be appropriate. And again, 60 days to try to get that done, understanding that it does take some time to get into somebody around here.
Is the court going to consider attorney's fees?
So in regard to attorney's fees, they're going to be denied. Again, I'm looking at two sides of this and don't feel it's appropriate to order attorney's fees.
And I understand the court is denying restraining order protecting the children, but is the court willing to grant a restraining order protecting my client, given the accusations involved here?
I don't see any reason to order the restraining orders. There's nothing to show that she did anything to him.
Just covering it, Your Honor, I understand. So does the court want to set a presentation date?
So we can do, where are we at on the 4th?
I'm unavailable the 4th, Your Honor. I apologize. It's
okay, the 11th, June 11th then.
If you, okay.
All right, is there anything else that I missed?
No, Your Honor, I think you covered everything.
And I apologize, Ms. Looney, you are an attorney on this case. I just want to double check with you to make sure you didn't have something.
No, Your Honor, thank you.
All right. All right, that concludes this matter and that concludes this docket.
Thank you, Your Honor.